What are we going to talk about today? We're going to talk about the First Amendment because you can't talk about Section 230 without talking about the First Amendment. We're going to talk about a very important legal case, Stratton Open versus Prodigy. Now, I know there's a few well-seasoned security professionals out here who may be familiar with Prodigy, the online BBS service. Those of you who aren't familiar with it, we'll tell you all about it. We're going to talk a little bit more about what Section 230 is, why you should care, and I'm going to provide you some resources at the end of this presentation for further reading, something you can curl up with if you live in the Midwest where it's starting to get a little cold. And that's basically what we're going to talk about today. First of all, for those of you who don't know me, I just got back from a trip to Morocco, so that's one of my favorite pictures right now. I am not a lawyer. I like to pretend that I understand the law, so please don't take anything I say as legal advice. Some of you may be familiar with Auditscripts.com, some of our free resources over there. Thank you. If you're not, we've got mappings to all of the frameworks. We've got free spreadsheets that will do assessments on the CIS controls. And I'm very excited. I had just joined Black Hills to help them build their governance, risk, and compliance practice. And there's my Twitter handle or X or whatever we're calling it today if you want to reach out to me. Okay, Section 230, what is it? This is going to be the one and only time I'm actually going to read this. No provider or user of an interactive computer service shall be treated as the publisher or speaker of an information provider by another information content provider. That's a mouthful, isn't it? But what that is, those are the 26 words that have created the internet as we know it today. This comes out of the Communications and Decency Act of 1996, but this is basically the heart of what we're going to talk about. Can Facebook, can Twitter, can Google be responsible for what users put on their platforms? Yes, no, maybe, depending on who you talk to. But first, let's go back and have a bit of history. Let's talk about the First Amendment. It's been a while since some of us have been in our social studies classes or our history classes. Let me remind you that the First Amendment is part of the Bill of Rights of the U.S. Constitution, and it actually contains 10 amendments that deal with freedoms. Freedom of expression. We've got freedom of speech, freedom of religion. But what we have here are these freedoms. We're very familiar with them. What we don't necessarily talk about when we talk about the First Amendment is it's not absolute. People say, well, I can say or do whatever I want, but that's not actually true. You may have heard the story about you can't yell fire in a crowded theater. You can't say something that's going to cause harm to other people. There are other prohibitions or restrictions within the First Amendment. We can't make false statements. There's no allowances for obscenity. You can't incite violence. These are all things that sometimes we forget about when the debate around the First Amendment gets a little heated. But let's talk about freedom of speech when it comes to things that are actually written down. What we have here, we have publishers or intermediaries is the term we use. And a lot of times people don't realize that they have limited immunity. When things are published, such as books, newspapers, they have limited immunity from legal claims arising from things that people have other people have written down or have produced. For example, we've got bookstores, we've got newspapers. Let me tell you about this picture up here. How many people have actually read this book? A few people? Well, back in November 2nd of 1960, there was a landmark obscenity case over Lady Chatterley's lover. It was a landmark case because they brought it against Penguin Books and they said, you're allowing obscenity, you're going against the cutouts of the First Amendment. You can't actually publish not only the cover of the book, but also the content of the book. And no, I haven't read it, but basically it has some, let's just say some steamy scenes in it involving an extramarital affair. And what happened in this landmark case is there was an acquittal of the publisher. And I'm bringing this up because this case sets the groundwork or the framework for Section 230 and the material that's produced on the internet. if a publisher can potentially be sued over the content that somebody else writes, how is this going to translate onto the internet and websites and website providers? This is what we're going to take a look at. So right now, these intermediaries have limited liability. But First Amendment actually has a blind spot. It provides immunity, but not to all distributors. We talk about freedom of expression. When publishers, distributors have illegal material or even material that infringes on somebody else's intellectual property, they lose their immunity, they lose their protection. I have another case for you too. Back in 1956, there's a case involving Eleazar Smith's bookshop. This is a very interesting case because this was back in Los Angeles in 1956. There was a book called Sweeter for Life. And there was an undercover police officer, and he had gone into this bookstore and he was kind of browsing and he found this book. And I don't even know exactly what was the content of the book, but he arrested the book clerk for providing obscene material. Now, the clerk was arrested and was released, but what happened is under the Los Angeles Municipal Code, the bookstore and the owner of the bookstore was liable because up there on the code, you see, it shall be unlawful for anybody to have any obscene or indecent writing, book, pamphlet, in a place where there's ice cream, soft drinks, candy, et cetera, et cetera. So now all of a sudden, the bookstore owner is liable. What they were implying in this is the bookstore owner now has to go through and read every single book, every single magazine before they could borrow or sell it. Sounds a little ridiculous. Can you imagine reading all the material on the internet and saying, this may be obscene for some people? So this particular case, again, sets the tone or the framework or the legal context for Section 230. Let's go to another pivotal case. Let's flash back to 1996. I've got Fox and Scully up there because it's the theme of the conference, the X-Files. And that guy down there did or did not create the internet. What he did is he created legislations that allowed the internet to be created. And, you know, he kind of gets a bum rap because everyone says, oh yeah, Al Gore, he created the internet. He was instrumental, but maybe he wasn't quite the engineer that he claims he was. But let's flash back to 1996 and Prodigy. Prodigy was an online service that offered subscribers access to network services. It was one of the major internet service providers of the 1990s, and they allowed users to dial into their data center in New York and access bulletin boards, chat rooms, the very early stages of the internet. One of the things it did is it provided a forum or an area for people to talk about finances. And it was an area called Money Talks, a very specific bulletin board. And in that bulletin board, there was an anonymous user who said that a particular investment firm, financial company in New York was committing fraud. Stratton Oakmont was that investment firm, and they sued Prodigy in a libel lawsuit for $200 million. Is a very interesting case because the judge ruled and said Prodigy was liable because it was a publisher of the information, not necessarily just a passive carrier. Now, what does that mean? Because they were publishing it and providing frameworks for it, the court decided that Prodigy was liable. But the judge also, what he kind of did is he kind of went soft on it and said, hey, this is a very important case. There's not enough case law developed because in our court systems, you know, we look at case law, we look at previously decided cases. Judges say what's precedent, what's been decided in other districts and other courts. And he said, hey, this is really still a developing area. We haven't kept pace with the technology, but you know what? I don't care. I'm still going to find them. This particular case got the attention of Congress at the time. And Congress said, We want to preserve this new beautiful thing called the internet. We want to see more commerce. We want to see more jobs. This, if a publisher up in New York is going to get fined, it's such a big amount of money back in the 1990s. We've got to do something that helps us protect this new technology, this new form of business, this new tax base. So what Congress did is they published the Telecommunications Act of 1996. It's also known as the Communications Decency Act, which is Title V of the Telecommunications Act. Section 230 is one big piece of the Telecommunications Act. Now, I'm not going to actually go through all the bits and pieces of Section 230. What I did is I basically highlighted the big things. Section 230 was designed to be a safe harbor. And I'm assuming you guys all know what that term means, right? A certain amount of protections. They wanted to make sure that these new website providers, not just the soon-to-be Googles and Facebooks and large technology platforms were protected, but mom and pop organizations. Think about it. You had grocery stores or little bookstores in mainstream America who were trying to reach their customers building websites for the first time. We wanted to make sure that they still had protections from that undercover cop who's going to walk in and say, hey, you're selling obscene material. So what Congress did is they passed Section 230 to be this Good Samaritan safe harbor. We don't want website owners to be liable. We don't want to kill this new e-commerce. We don't want to kill the internet. So let's pivot a little bit. And a lot of people will say, is Section 230 the most important law for tech, or is it kind of a hindrance? Here are some of the latest news articles. We've got people complaining about Facebook. How many people got kind of in conversations or discussions with their neighbors about COVID vaccines information being put on Facebook? Or how many people have heard the articles that Twitter has disinformation about the war going on in Israel and against Hamas right now? Or do you remember when Trump was upset that he felt that the social media companies were too liberal leaning? And he actually issued an executive order because he felt that there was censorship happening on the platforms. So I bring this up to say there's a lot of opinions and a lot of people talking about Section 230 right now because people feel there's disinformation. They feel that it's not good for society. If we're spreading information that may or may not be true, influencing people. Now our Congress people, our lobbyists, our thought leaders, our law professors are now engaging in looking at Section 230 because 1996 now to 2023, things look a whole lot different. We've got different technologies. Everybody has a phone in their back pocket or in their purse now. So as an organization, as a country, we're starting to look at, is Section 230 still good for us or not? Pros for Section 230: encourages free speech, protects our tech platforms, reduces burdens on the court system. Can you imagine if we still had all of these cases where somebody was being fined for potential libel or slander because somebody didn't like what they said about them, or somebody said, nah, I don't like what my neighbor said about me on Facebook. So there really are pros for the protection of Section 230. It helps us facilitate access to information. Again, reduces burden on the court system. I don't know if anybody's been to court lately. I'm going through a situation where I need to go in front of a judge, and it's a 1-year wait to actually get a court hearing in Florida. So this particular one, reducing the burden on the court system, kind of appeals to me as well. But other people see cons for Section 230. It doesn't really address harmful content. It doesn't address wrong information or strongly worded opinions that may sway people towards violent actions. There's uneven content moderation. You've seen the articles that talk about, well, Elon Musk won't put this on Twitter, or some people, in fact, just this morning, the New York Times lost its verified check code because he was upset at them. Other things, cons for Section 230, it doesn't necessarily address disinformation. And we also have decreased platform accountability. So at this point, I've kind of highlighted both pros and cons, and I'm trying to be very careful to not get political and not say pros and cons, or because I know this can be a very heated article, especially or a topic area, especially when it comes to politics, when it comes to vaccinations. So I'm trying to be very careful here, but I do want to highlight a couple big cases that came in front of the Supreme Court this year. And because the Supreme Court had an opportunity to weigh in on Section 230 and they chickened out. And therefore, I had to redo my entire presentation because when I submitted this back in March, I'm like, oh, this is going to be so good. We're going to have new information on Section 230. The Supreme Court's going to weigh in. Too long, didn't read. They didn't address Section 230. But I want you to be aware of these couple court cases because they're very interesting. We've got Twitter versus Talma. This goes back to 2017 when there was an attack in a nightclub in Istanbul, killing 39 people, including a U.S. citizens. The family decided to hold Twitter responsible for housing ISIS content prior to the attack. The plaintiffs argued that Twitter, Facebook, and Google's recommendations promoted terrorist-related content. That's kind of a big stretch. The interesting thing about it is there's a term, it's really difficult to say, called certiorari, which means that the Supreme Court is going to hear a particular case because it's been appealed in the lower cases. The court case for Twitter versus Talma went to the Supreme Court, and they actually made a decision on it in May and said, this has nothing to do with Section 230, nor does it violate JASTA. And if you're not familiar with JASTA, JASTA is the Justice Against Sponsors of Terrorism Act. So they were basically, the legal team was trying to take two different tactics here. They said, well, it either violates, it's a Section 230 issue, or it's a JASTA violation. The Supreme Court ruled that this particular case didn't provide enough merit to discuss Section 230, and they said it wasn't in violation of the JASTA Act. So they actually vacated this decision. The other court case you may or may not be familiar with is Gonzalez versus Google. Again, another unfortunate terrorist attack. 130 people were killed in an attack at a Paris nightclub. This was back in 2015. The particular argument was that YouTube had led users to commit the attack by providing recruitment videos on their platform. And the lawyers were actually trying to argue that Section 230 was involved because they were providing an incentive for attackers. And again, this gets really kind of sticky because not only is it that JASTA Act, but it's also Section 230. And again, the court issued decisions for both of these cases saying Section 230 they didn't provide enough explanations or a good enough argument to handle Section 230. Actually, my personal opinion, I think the court just didn't really want to tackle such a large issue because Section 230 deals with all platforms, all content providers. Like I said before, everyone from Google and Facebook all the way down to the mom and pop shop that has just a very simple little website. So questions to ponder without getting too political or too dicey topics. Can tech platforms be liable for amplifying harmful content? Do we need to regulate big tech? And even that term, some people don't necessarily appreciate big tech, but we're talking large organizations out in California, the Facebooks, the Googles, the Twitters. Is some social media content harmful to people in society? These are questions I think you should be having conversations with over a nice glass of bourbon or as you're walking your dog. But I bring these up because our fellow citizens, some of our non-technical community members, family members are asking us these questions as technology professionals or privacy professionals. So I put these up here because I want you to be able to have a good conversation with them and say, well, here's what I think about it. Introduce them to Section 230 and say, this was why the internet was designed the way it was, to allow for freedom of speech, but not hold publishers and intermediaries responsible for the content that their users have provided. I will give you my personal opinion here. I think there are some resources I'm going to show you on the next slide But I think there is a position shift that we need to talk about. And we do need to talk about due care from our providers. There are things our providers can do to limit pornography, limit the trafficking of women and children, along with users, our friends, our coworkers, having some personal responsibility from posting just junk and crap online. So the way I see this going forward with Section 230 is we have a shared responsibility. Not only are we going to ask the providers to step up and maybe filter content a little more carefully when we know it's obscene or we know it's against the law, and also for us to take some personal responsibility about what we post online. So I promised you some resources. I was kind of inspired to do this talk by reading the book, The 26 Words That Created the Internet by Jeff Kosoff. He's a law professor. He also has another book coming out on October 21st, called Liar in a Crowded Theater, Freedom of Speech in a World of Misinformation. And I'm looking forward to reading that. EFF has some fabulous resources on Section 230, and they have a whole section on additional court cases that pertain to Section 230 that talks about going back to the time when Yahoo had online dating profiles. So if you want to learn more a little bit about some of these court cases leading up to it, EFF, great resource. I also am going to point you to a legal paper by Professor Citron. If you're not familiar with her, she's an incredible privacy advocate, but Professor Citron has a paper called How to Fix Section 230. And in there, part of what she's also proposing is everybody stepping forward and taking a bit of responsibility, but she kind of puts it under the umbrella of due care. And you're starting to see this term a little bit more and more, especially in cybersecurity and privacy, where we're defining what due care looks like. For those of you who don't know, the CIS controls were listed as an agent or a vehicle of due care in the state of California when Vice President Harris was Attorney General. And I also have another article up here from ITIF on an overview of Section 230, what it was, why it was created. I put these resources up here because I know people are going to be coming to you, asking questions, and I want you to be informed because you are a leader, and this is a topic I think you're all fairly passionate about. So I really appreciate you coming to my presentation. It went faster than I planned because I'm talking faster than I planned. But does anybody have any questions?
Why is this any more complicated than the carrier versus publisher idea? And are we not having some businesses trying to straddle that legally?
I'm not sure I understand your question.
So my basic understanding back to 230 was that, like you said, for an ISP, because I happen to work for an ISP in South Dakota who worked with Larry Pressler to write that code. The idea was, like you said, the mom and pop. We're an internet provider. We don't editorialize. We provide services to everybody who comes to us versus like a newspaper publishing information. And so they're editing content, creating content. And that was my understanding of the basic split. A carrier like the telephone company carries every customer. They don't edit phone calls. You have someone else, like a newspaper, would edit what you're putting out. So that's where I thought the split was, and that's why I see it seems more content like Facebook is trying to straddle that of being an editor and a carrier.
You're exactly right, and that's part of the problem. Is some of them are editing content or not allowing content to be provided, and they are crossing over into a line they don't belong in. But then there's other organizations and there's other lobbyists, Congress people who want them to straddle the line because they're saying you're not protecting our kids, you're not protecting our users enough. That's why I think Section 230 is such an important issue, because we're seeing more and more headlines and people are getting more and more engaged, and the line needs to be more clear.
Perhaps one of the difference in kind is the amplification algorithms on those platforms, so the asymmetric effect of them. But I think that, I'm biased. I think we should just get rid of laws in Congress and do software code commits. And it's too late. Laws are going to save us. People are going to go to decentralized platforms. Law's not going to fix this.
Personally, here in the United States, we hold freedom of speech and our freedom of expression, religion, yada, 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 very highly It's important to us. Not every other organization, country, nation state holds those same values. And it makes it very complex because we know there are organizations, countries out there that censor a lot of information. But we could be on the spectrum where we allow too much information and too much garbage on the internet. So where is that fine line of due care between the publisher, the creator, or the editor?
Why don't they just start with a requirement for attribution where you have to sign a hash of the content you create with your private key, and you can attribute the trail, the origin of all the information, and go from that angle.
That would be awesome, but not everyone understands hashes, right?
TTP isn't that hard.
It's a very complex issue because some people don't want to hear, let's say I'll pick a tender topic here. Let's say you're a gun owner. You don't want to hear about gun control. You're like, over my cold, dead body. But then there are other people who family members have been victims of attack. They don't want to be susceptible to it because they don't want to hear about it. It brings back hard, painful memories. So how many people go to Facebook for their news? Anybody? Do you have family members who go to Facebook for news? Does that make you cringe? And I'm not picking on Facebook, but was Facebook designed to be a news provider? No, it was designed to be an opportunity for people to share thoughts and information and where the next party was. But okay, so we understand Facebook. It's a social community, but let me ask about Twitter. How many of you go to Twitter or X for your news? As we're building communities, not only in the towns we live in, but online, we have to make sure that the information being shared is good, is accurate, and is comprehensive. IAPP is the International Association for Privacy Professionals. They provide not only good guidance on privacy laws, they're also really starting to venture into cybersecurity controls and privacy controls and how they work together. One of their biggest projects they just released was an artificial intelligence governance center. And it's a place for white papers, a place for data scientists to share information. And what they're working on is a artificial intelligence governance framework. They're kind of trying to step out and lead efforts there. Another great source for information is the SANS Institute. If you read some of the reading room papers, those are papers written by master's students, and they'll actually go in and dig into a particular topic. But I really appreciate all of you coming to the presentation today. I know the weather's really good out there. I hope I've enlightened you a little bit about Section 230, or at least given you some questions to think about, questions to ponder, because maybe the Supreme Court didn't deal with it this year, but it's going to come back. And some people are advocating for a change of Section 230. Other people are advocating for a new federal privacy law that would sort of circumvent what we see in Section 230. Because really, some people are more concerned about how data is used, if it's accurate, and who has access to it. That really belongs in a federal privacy law, not necessarily Section 230. Any other questions, folks? Oh, there's one in the back.
So one of the difficulties that I have is trying to figure out like what layman's terms versus what legal terms are going to be. So my opinion on Section 230, based on the way I read it, may be different from the way that it's legally interpreted. And then that is also going to be different from the way that it's being construed to me by different news sources that are going to have their own agenda that they're playing at because they want it or don't want it for different reasons. Do you have any recommendations on kind of sifting through all that information?
Let me go back to my resources slide. I tried to provide a bit of variety and not just the liberal sources or conservative sources. But the question is, how do you make sense of this? And it really depends on what role you're in. If you're in a governance, risk, and compliance role, you may have to defer to what your legal team is saying and their interpretations of it. And especially if you're working for a technology platform, internal legal department, what's their number one job is to defend the company. So they're going to tell you how they want Section 230 to be interpreted if you're in that type of organization. But then you've got other people who see it from a personal privacy and personal freedom and rights issue. So I think my best recommendation is try putting on different hats and say, how would my neighbor see this who doesn't understand technology? How would a corporate attorney view this? And kind of just read different articles or books depending on what you're interested in at that time and what perspective you want to shore up on.